Hello guys, let's begin. So I will start from here today. Sir Henry James Sumner Manny, a British jurist and legal historian who pioneered the study of comparative law, primitive law and anthropological jurisprudence, is main exponent of British Historical School of Jurisprudence. He was a professor of civil law at University of Cambridge. He was a member of Council of Governor General of India and substantially contributed to codification of Indian law. He is famous for his notable work Ancient Law, its connection with early history of society and its relation to modern ideas. To trace and define such concepts, he drew upon Roman law, Western Eastern European legal systems, Indian law, and primitive law. So, to define this book and its various concepts, he made up Roman law, Western Eastern European legal systems, Indian law he codified, and primitive law. Many explained that growth of law took place gradually in various stages under a static society in the following sequence. So there was a particular society in which various stages took place, and because of that, law grew in the way as it is today. Divine law, law of God, Themis judgments of goddess of justice. Divine law, that is something related to natural law because it also considered law to be something law of God, which is made by law, which is made by God, which is connected to nature. It is immortal. Customs and traditions which are prevalent in that society. Era of codification. However, in a progressive society, law evolved through three stages: fiction, equity, and legislation. Fiction means there was a fictional situation, equity to bring equality, and through legislation, debates, discussions, it was evolved. Now, Themis, this box information. Themis was Greek goddess of justice and was considered embodiment of divine order, law and custom. So it is very important who is considered as the Greek goddess of justice, Themis, and she was the embodiment of divine order, law and custom, because it's goddess, so something divine, something powerful of law and order. Themis signifies divine law in place of human audience. So in place of the human orders, Themis is what? Divine law, that is law of God. She was goddess of divine law and sat beside Zeus, the father of gods, to offer advice. She was considered the divine voice who first instructed mankind in primal laws of justice and morality. Even the historical approach is not free from criticism. As I said, nobody is perfect. So as these schools were also not having, it's not that they were also perfect and they never had no loopholes, but they were not also free from criticism. There were many problems with this, and it was rejected on ground of its vague, parallel, unscientific explanation of law. Now we come on to Sociological School. Exponents of this consider law as a social phenomenon. Now it is sociological, so something related to sociology. That is, it considered law to be a social phenomenon. Social means related to society. It visualizes law from perceptions of people in society. As I told you just now, it relates to society. So whatever the thinking and character and the mindset of people in that society is, they frame law according to that. So sociological school, perceptions of people living in the society. This emphasizes on balancing conflicting interests. The sociological school considers law as a tool for social change. That means whatever the people think, that depends upon that what law is framed in that society, and that is sociological school. So whatever social changes, mindset of people is changing, depending upon that, whatever their thoughts and expressions or interests are, depending upon all these things, laws are framed. Followers of this school insist on the fact that law exists for needs of society. Philosophy of sociological approach provides an opportunity to social and legal reformers. Reform means to change as the societal conditions change and as the thinking or mindset of the people change. According to that, law has gained a reform. So law exists as per the needs of the society, whatever they require, whatever their thoughts or interests are. Roscoe Pound, an American jurist, was considered as chief exponent of sociological jurisprudence in US. Léon Duguet, a French jurist, studied law at University of Bordeaux and was appointed as a professor in Faculty of Law at Keene in 1883. Duguet had a significant influence on French public law. Duguet considered law as a tool for enhancing social solidarity. Solidarity is living something alone, right? So Duguet considered that to enhance the social solidarity, law is very important because it will be establishing a connection or an interdependence link between human beings. D. Rudolf von Ehlering, a German legal scholar, developed a philosophy of social utilitarianism that emphasized the needs of society, which is different from individualist approach of English utilitarian philosopher Bentham. So the Rudolf von, this person developed the philosophy of social utilitarianism, which means that whatever the needs of society will be rather than individual person's need or individual approach, whatever the whole group of societal people will decide and whatever their needs or interests would be, according to that, law will be framed rather than the approach of a single person. Eugen Elrich, Austrian legal scholar and sociologist of law, emphasized the importance of social sciences to understand law. He considered it as a social institution created to satisfy individual and social wants. Most of thinkers of sociological school also emphasized the fact that law is a tool of social engineering to balance conflicting interests. So many have this thought that law can be seen as a tool of society to balance the conflicting interest, because any two person, even if they are living together, they will have some opposite interests. So to balance that conflict, law has come as a tool. ना तुम्हारी ना मेरी, किसकी? law की. ठीक है? So to balance that, law is a tool. Law is a bridge to balance the conflicting interest of the society. And it will also satisfy the individual and group needs. Whatever a single person needs or whatever the whole society needs, that can be satisfied and fulfilled by law. And to balance, to remove the conflicts also, we have law. According to Roscoe Pound, the main features can be summarized as follows. It highlights purpose and function of law rather than its content. What the function and purpose is: to bridge the conflicting interest and to satisfy what the people want, what their interests or welfare is. So not what its content is, but what is the function and main purpose that why law has to be framed. It is a social institution designed for social need. It is a tool to balance, as I told you, same things. Main criticisms. Now what were the criticism against this school? Terms social solidarity and social engineering are vague and create confusion. Now you see, everywhere there is some sort of confusion which is created. So over here, the terms social solidarity, social engineering, which has been used many a times, they consider it to be vague, which may create some ambiguity. Men and society can be compared with machine. Jurist like Doggett overlooked the importance of state because he was saying that whatever the society thinks, he was not talking about as a government or the state. Sorry. The concept of social engineering revolves around creating an efficient societal structure which results in maximum satisfaction of wants with the minimum level of wastage. So this was given by Roscoe Pound, and he said that whatever is social engineering, now you see these terms were creating confusion. Now let's see what is social engineering. Social engineering means whatever things you are doing to create a societal structure, so that as we say now the majority wins. So over here you have to see what conditions will be that results in the satisfaction of maximum people of the society. maximum people का satisfaction हो जाए, उनके जो wants है या उनकी जो needs है वो पूरी हो जाए, so that there is मिनिमम लेवल और लेस और नो लेवल ऑफ वेस्टेज. ऐसा कुछ बनाए, ऐसा डिस्ट्रीब्यूशन करें या ऐसा लॉ क्रिएट करें जिससे कि मैक्सिमम पीपल आर सेटिस्फाइड एंड देयर इज लिटिल और नो वेस्टेज. According to Pound, law is social engineering, which means a balance between competing interests in society. So this social engineering is what? That law is social engineering because it acts as a balance between the conflicting interests. Realistic school. Realistic considers law made by judges as real law. They give less importance to traditional rules and concepts as real sources. So they consider that traditional rules, customs, all these are not laws, all these are not the real sources, but whatever judgments or whatever laws are given by the judges in their verdicts, that can only be considered as real law. Realism is contrary to idealism. It is a combination of analytical positivism and sociological jurisprudence. So what is realism? Analytical positivism and sociological jurisprudence. Sociological school we did and analytical school also we did. So when we combine these two, we get realistic school. Realists do not give much importance to laws enacted by legislative bodies and consider judge-made laws as actual law. So they don't consider those legislature laws or bills. Whatever they consider is what the verdicts are given by the judges in the courts. When they give a new verdict and that becomes a law, like they give the verdict in right to internet recently, Kerala High Court gave the verdict that right to internet is also a fundamental right. So that had become a law now. Now it is a part of law that right to internet is a fundamental right. So whatever the judges say, whatever they give in their verdict and that becomes a law, that is only real law. That is only the actual law, according to the realistics. Realist place great emphasis on role of judges in implementation, interpretation and development of law. That is true because they only in reality implement and interpret that what all provisions are actually there in the constitution. They know how to implement those provisions. I'm only taking the example of constitution. Every other book of law also, they only consider that what in a section or what in an article is given, how they have to implement it in the present case that is in front of them, how they have to interpret the line or the statement given in that section or provision, and how then they have to implement in that case, and then they have to give the verdict. So that is all truly upon the judges. They have a very significant role in that case. Realists believe that social, economic, psychological background of a judge plays an important role in his decision making. Whatever the social, the political, जो brain से उसका development हुआ होगा, जो background होगा, that depends that what kind of verdict. हर चीज़ में एक family background matter करता है. तो sociological, social background of a person, if he becomes a judge, तो वो background बहुत important part, बहुत important role play करता है that what sort of decisions he is gonna deliver. Realist school can be further divided into two parts: American realism, Scandinavian realism. Prominent American jurisprudential scholar Carl Levin, who was associated with the School of Legal Realism, had identified some of the main features of this school. Law is not static. I told you, I gave you that example also. As the laws due to course of time becomes obsolete, a new law is brought onto the old one place, or there are some changes. Law is a means to a social end. Society changes faster. Because of that society changing faster, laws also keep on changing. Law cannot be certain. Decision of courts depend on many factors, various different circumstances, various timelines. Whatever the different circumstance or particular circumstance or merits of the case are, according to that decisions are given. Whatever we say according to discretion of court, means whatever judge is sitting at that time in the bench, according to his mindset also, what would be its verdict, nobody can decide. So decisions are not certain. This day this person will deliver this verdict, that will become a law, it is also not certain. So that depends upon what the judge is thinking at that moment. Depending upon that's why we say discretion of the court. Depending upon the discretion of the court. So that depends upon the, as we read just now, psychological, social, economic background of judges. Case studies are important, and courtroom is a laboratory of law, because they implement, they interpret the statements, and then they frame new laws. As you do in the science laboratories, you mix two chemicals and a new compound is formed, you do various reactions. So similarly, with the present laws, they implement it, they interpret it in their own way, they combine it, and it may happen that a new one is framed. So they keep on experimenting. Major criticisms: it ignores importance of legal rules enactments, which can lead to confusion. Now they only consider what the judges are delivering the verdicts. They do not consider those legislation rules and enactments, the amendments, they don't consider it. So ऐसा नहीं है कि लेजिस्लेचर जो काम कर रहा है वो बिल्कुल ही ख़राब है. हर चीज़ की अपनी एक इम्पॉर्टेंस होती है. वो जो रूल्स बना रहे हैं उसकी भी इम्पॉर्टेंस है. सो इफ़ यू आर टोटली इग्नोरिंग दैट इज़ रॉन्ग. It is incorrect to think that law evolves and develops only and only through courts. सिर्फ कोर्ट ही लॉ बना सकता है, that is wrong. Legislature is also the body. लोग भी अपने आप अपनी नीड्स के अकॉर्डिंग बोल सकते हैं. Unwarranted emphasis on judges' behavior in judicial decisions. You are totally depending upon that. Conclusion. From above description, it may be interpreted that these approaches can neither be accepted in totally nor rejected completely, because here we were presenting some merits and demerits of each and every school. Every school has its own approach of understanding and explaining. These theories are products of certain times, places which are relevant only in a given setting. Some part or parts of above enlisted theories might have become outdated or unacceptable in present day scenario, but all of those cannot be totally rejected. So some you can implement, some you can ignore. Now you see this flowchart. You can make, if you want, in your notebooks and learn it, or you can refer it to get an understanding, to brief understanding. Now we come on to the last topic of this chapter, that is function and purposes of law. So we have discussed the meaning of term law. It is a natural question to ask the following questions: why is there law in society, what is the need of law, etc. Functions and purposes have been changing with time and place. They depend on nature of state, what kind of people are living, what is their requirement of, what is their upliftment that they require, the welfare, the interests of the people, the needs, the wants of the people, that all decide that what type of law would be framed in that society. At present, in a welfare and democratic state, there are several important functions of law. It can be stated that law starts regulating welfare and other aspects of human life from a moment a child is conceived in a mother's womb. In fact, state interacts with and protects its citizens throughout their lives with the help of law. So it is with the help of law that the government or the state is connected with its people, with the
people of its nation, and it also protects and take care of the lives and requirements of the people. Like it is said that the supreme lawmaking body, that is constitution of our country, because of that the government interacts, has a connection with the common public, and whatever decisions or laws they are framing, that is most of the times for the welfare of the nation, for the welfare of its people, and it is always in the requirements and in the good interests for the common public. Now let's see some of the major function and purposes of law: to deliver justice, to provide equality and uniformity, to maintain impartiality, to maintain law and order, social control, to resolve conflicts, that is subjudicating the matters. लड़ाई कोई हुई है तो कोर्ट चले जाते हैं, तो कोर्ट कैसे करती है? लॉ से ही तो करती है। जो भी लॉ, जो भी लेजिस्लेशंस बने हैं, उसको देखते हुए भी वो अपना वर्डिक्ट सुनाती है, और तब हम कहते हैं कि मैटर रिजॉल्व हो गया, ख़त्म हो गया। टू ब्रिंग ऑर्डरली चेंज थ्रू लॉ एंड सोशल रिफॉर्म, तो ये बहुत कॉमन चीज़ है, कुछ समझाने का नहीं है। एंड हेयर वी हैव completed our chapter 1 of unit 2. Now next video we will be starting off with this. Thank you.